Hello everyone. Today we are here speaking with Senior Advocate Gaurav Chopra. He was designated by the Punjab and Haryana High Court, making history for his alma mater, the National Law Institute, University Bhopal, by being the first alumnus to be conferred the gown. Good morning, sir. Thank you for joining
Good
us
morning.
today.
Good morning. Good to see you.
It's a pleasure. So to begin with, sir, where did your interest in the law stem from? Do you come from a family of lawyers, or was there a different inspiration?
No, yes, I do. So I'm a second generation lawyer. My father himself was a senior designated counsel before, so he got designated in the year 2001. So I have that exposure to the legal field profession, as you may call it. So that's how I took it. So basically, right from the time I was in my ninth standard, I told my parents there and then that I would want to be a lawyer.
That.
So
So, you're from the pre-CLAT era of law schools. How did
that's
NLIU Bhopal happen?
So it happened by chance, to be very honest with you. So basically, so way back in the year 1998, at that time, they only used to be the National Law School. So I'd taken the competitive exam for the National Law School after my +2 board examination. And I secured the All India 80th rank. But as luck would have it, I didn't manage to get it through. So then thereafter, I had applied for some graduation courses. But while that was underway, I came to know through a very dear friend of mine that there was something on similar lines as the National Law School, which was opening up in Bhopal. So then I got a copy of that employment exchange news, that paper, and then I applied for it. And so then rest, as I say, is history. So I participated, I appeared in the competitive exam, and I was All India rank holder 1 in that competitive exam. And that's how I ultimately cracked the National Law Institute. At that time, it used to be called the National Law Institute, and the university tag was added later while we were still studying there.
Okay, and how was your time at law school?
It was fantastic. Perhaps the 5 best years of my life, and very formative years. So, because when you go to a professional college and when you're staying away from your family, staying in a boarding, it teaches you so much how to be independent. And then, it gives you that education rather of developing relations, how to manage everything while you're away from your family, because in your family, you're in a very cocooned atmosphere, very protected atmosphere. There you are basically, being prepared for how to handle the world when you enter the professional field going forward in your life. So
Right.
fantastic. I have very, very fond memories of very, very strong friendships, which have lasted the duration of time. It's been almost 25 years now. We'll be completing 25 years since joining college in 1998. So yeah, it's been fantastic, and I have absolutely no regrets.
And so, there's been a lot of discourse, especially recently in the legal profession, about nepotism, particularly in litigation. As
Yes.
someone who comes from a family of lawyers, are there any unique challenges that you face that sometimes people may be oblivious to?
So mine is a very strange kind of a case. So essentially, while I am a second generation lawyer, I didn't get enough time to spend with my father. So when I joined in the year 2003, this is like 1st of July 2003 is the first day when I accompanied my father to the court, my first day in court rather. So my father unfortunately passed away on the 8th of August. That's just 1 month and 1 week thereafter. So I never got that so-called advantage. There were disadvantages, but the advantage was that yes, I was still a person who belonged to a family or who was the son of a father who was a very well reputed lawyer, very well known. So yes, that was just one advantage. I inherited an office. That was a great advantage. But then the level and the burden of expectation, that if you do well, you're bound to do well. Why? Because you're somebody's son. If you don't do well, then you are a blot on your father, etc., etc. So that kind of thing. So with me, it's a very unique kind of a thing. But yeah, given an option, I mean, see, nepotism. I don't know. It's just a very exaggerated concept. There's nepotism. I don't agree. See, ultimately in this profession, it's your hard work, your delivery in court, your level of preparation, which will determine whether you make it big or not.
Mhm.
And I believe it will be very unfair for anybody to not give credit to a person who, despite belonging to a legal background, does well. So it has its own shares of ups and downs, as I may say.
Okay. And
Yeah.
why did you choose to set up practice in Chandigarh? Many in the city itself sometimes prefer to start in Delhi or other metros. Was that because your father practiced there, or was there any other reason?
Yeah, so the fact that I came back to Chandigarh and started practicing was all because of my father. So it was a time when you get those campus placements, and also I had offers, and I wanted to be in Delhi, the glamour of Delhi, and at my age at 22 when you're graduating, so that's a very big deal. And then I spoke with my father, and my father was very encouraging. But my father said that with time I'm also getting older, might as well come and join me. Rest is up to you. And I took that decision because that was the first time ever that my father had ever asked me to do something. And little did I know, like, going forward, that perhaps would be one of the best decisions that I ever took, because at least I got to spend 1 month with my father. And even in that 1 month, my father used to discuss so many things with me, share so many things with me, tell me so many things, which I have not forgotten. I mean, each and everything that my father used to share is still very, very fresh in my mind. So I was destined to be in Chandigarh, is all I can say, to put it simply and bluntly.
So, whom did you actually start your career with? Were you on your own in your own practice from the very beginning? Can you recount some of your initial years at the bar for us?
Oh yeah, absolutely. So I had to take over the reins of the office after my father passed away. I didn't have the occasion or the option to actually work under anybody. I had to handle litigation as such, that litigation actually travels with the lawyer. So the moment my father passed away, there was the propensity for clients to actually take back the briefs, because I was a newcomer. And my father at the time when he passed away was a designated counsel. So it was tough. I used to spend countless nights, endless nights, and sleepless nights, and go to court, because I had to learn everything on my own, and I learned from seeing uh, the stalwarts in my profession argue in court, be amazed at the kind of level of preparation that they had. And so that's basically my grounding. That's my education. So I never got the chance to work under anybody. During my college days, I did an internship for a month with Mr. KTS Tulsi, senior advocate. And before that, I did an internship with Pathak and Associates. That's a law firm in the CP area in Delhi. And that's it.
So, was that a struggle to start all on your own from the very beginning? Because most people tend to learn and take some time to get settled into the profession. I'm sure it wouldn't have come easy.
Absolutely. Absolutely. And those were the days way back in 2003 when we didn't have the advantage of having all the journals on the computer.
Mm-hmm.
There were no softwares, nothing. So we used to do, I mean, I personally used to do, because gradually over a passage of time, because I was the youngest and I had to take over the reins of the office, I was left all by myself to manage the entire set of cases in the office. So I used to spend time at night. I used to do my research on all the journals, all the cases myself, which is why the sleep pattern in my life was the biggest casualty. And now when I look back at it, I look back at those times very fondly. In a sense that that period from 22 to 30 is basically a time when you get that time to settle into the profession. You learn. There's not too much stress or burden of expectation. With me, the burden of expectation was there, not from the world around me, but more importantly, the expectation that I had for my own self. So yeah, those sleepless nights and all that. But now when I look back at it, it's been worth the journey. It's been. I would not trade it for anything else. Yes, my experiences in life were such that my father passed away. That is something that obviously nobody would expect, nobody would want. And given an option, that's the only thing in my life which I would ever want to go back, rewind, and undo. I wish life had that rewind button. It doesn't.
So
But it's
when
been
did
good.
your
It's been good.
yeah. So when did the designation happen?
So the designation happened in May 2021.
Mm-hmm.
So we had applied. So the last designation in our High Court took place in the year 2014. And after that, because of the proceedings in the matter in Mrs. Indira Jai Singh's case, things got deferred. And once the judgment of the Supreme Court came laying down that criteria, Then the rules had to be framed by my High Court. And then 2019 is when the High Court sought applications for senior designation. And while that process was underway, we had COVID and then things got stuck there. And then ultimately in 2021, the permanent committee submitted its recommendations. We had the interview and then the full court decided the way it did. So it's after 7 years, after exactly 7 years, the designation took place.
Okay. And, in 2021, there was also following the designation a big controversy surrounding them. And do you think the current system of conferring the gown needs further improvement?
See, perhaps it will not be right for me to actually pass a judgment whether it requires any modifications or not. I believe to a very large extent, by virtue of the fact that the Indira Jaising judgment has now come, it has become objective insofar as the assessment is concerned because of that 100-point table. But that being said, see, I mean, one thing is very sure and very, very clear. When you say designation, you are conferred a designation. It's not your right to be designated. It is something that the honorable judges of the court who have seen you perform in court, who've seen what kind of delivery you do in court and how prepared you are, etc., various attributes. So because of the fact that it's a great honor that is conferred, I don't think that anybody should actually claim it as a matter of right. Mm-hmm. That's my take. That's my take on it. But yes, I mean, to some extent, the criteria has been objectified a lot. Because of the judgment, and going forward, perhaps it might be made more objective. I don't know. But I believe the full court should always have the final say so far as conferring the gown. That's my take on it. I've been reading about various litigations that have now reached the Supreme Court again regarding clarifications, etc. Well, everybody is entitled to their own view. But I believe that once the permanent committee awards you marks and then perhaps prescribes a cutoff criteria for recommending the names of the people that they have shortlisted for designation, the final decision should always rest with the judges because they are the best, they are the best adjudicators of your performance in court. And it's not the number of years that you've spent at the bar, but various attributes that they personally believe. Because when you see, I was told, and that's a very humbling experience. So getting designated is the pinnacle in a person's profession. There's nothing better. There's nothing more important. And that's the height. But when you actually travel from your high court to another high court, you are then representing your high court. And that is something that I have not lost sight of. And I believe that's a great responsibility that the judges have conferred upon you or have reposed in you. And I believe so, yeah, those kind of attributes.
Okay, sir. So you were the first from an NLU aside from NLS Bangalore, I believe, to be designated. How does that feel to carry that?
Frankly, I didn't even know about it. It's when I got designated, and you have those forums. I am not a part of those forums, and then I have my classmates, batchmates from college, my juniors from college, and they then started sending me those congratulatory messages on WhatsApp. And then they started sharing those forums, and I was like, okay, really? I'm the first. So these are all statistics.
Do you think it's a burden to carry, or do you think it's more of an honor?
No, it's not a burden to carry. I don't think so. I think it's a distinction, and I wouldn't call it a burden. It is a responsibility, but that's a responsibility that, in my own estimation, I have been shouldering since the time I joined the profession, because my own expectations from myself are the benchmark with which I always compare, and then the results follow.
Okay. And so, do you think with changing times, tags like NLU, non-NLU, these things are meaningless, or do you think they hold value still?
I don't think they hold any value, to be very honest with you. These are just things that we create in our own head. I don't know for what purpose, for what is the end result. I don't know. See, so from people from my college, say for instance, there is absolutely no question of a comparison with any of the other law colleges. I mean, people who are the alumni from the other national law institutes or non-national law institutes, they do well. The idea is to clap for them that they have done well and to wish them well for their future. But so far as my college is concerned, so on an individual level, it acts as a source of inspiration for each and every person who has now become an alumni from the National Law Institute University of Bhopal to aspire to be a designated counsel. Because all of us, I mean, I believe I can say for almost everybody who gets into litigation, that should be the goal. It happens, it doesn't happen, we have to leave it to our destiny. But we have to work hard. But yes, so it's a source of inspiration. And because of that source of inspiration, if more people decide to join the profession or whosoever are in the profession, they have that aspiration that, if Gaurav sir can do it, so can I. I think that's the best thing that could come out of designation from my institute's point of view.
So, and what do you think? What are your thoughts on the new crop of sort of young law graduates? How do you think they differ from more senior lawyers such as yourself?
Well, first of all, they have access to technology. So that actually, that to a very large extent blunts the advantage that a senior will have. Yeah, a senior with the passage of time, with his experience, would know which point to impress upon the court, what is the strongest point in the case, what that you have to research on. But I think the greatest thing is the technology advantage. It, I think, is also a very big disadvantage. So, way back in the day when we didn't have the advantage of technology, we used to have those journals. They used to come every week, like parts. And I, for one, on every Saturday, because Saturday is the only time that we get an off. Sunday is also a working day for us. We are in office from morning till evening. Saturday, I used to pick up those journals and I used to always update myself on whatever the law is. And I used to make notes. I used to prepare a register and I used to take down notes, so that whenever there is a case which involves a similar kind of a fact and you're looking for a ratio, you just, have the advantage of taking out your register and just seeing that judgment citation and taking it out. It saves a lot of time. Today, that doesn't happen. For the simple reason that you just go on a software, be it SCC Online, be it Chavla publication, RCR, etc., put in a keywords and then get the judgment. Second, the fun of reading a judgment from the book. I'm slightly old-fashioned that way. I mean, you don't get the same kind of fun in reading a judgment from a printout, which we now prepare compilations of. So yeah, but that's that. And I believe compared to what the exposure that we had, the people who are joining the profession today, the exposure that they have, the vision that they have, or rather the horizon has widened so much. So that is definitely an advantage that they have. But yeah, I mean, technology does have its own advantages and disadvantages, as I just mentioned.
But I also want to understand what you think about their approach to the profession. Do you think there's a change, or do you think it's sort of similar? Do you think that it's uniform?
There I see a huge disconnect. So I see a lot of youngsters, and I do interact with a lot of them, with God's grace. I see a lot of youngsters who, it's a very tough profession. I will absolutely not be critical of whatever they're doing. It's a tough profession to be in. You obviously, some people or a lot of people don't have the luxury of time. You have to fend for yourself, you have to fend for your family, you have to earn, etc. This profession, at least for the first 5 years, is not at all financially rewarding.
Yeah.
In fact, you have to do a lot of hard work. You have to be very patient. It's easier said than done. So yeah, I mean, what I see is that the propensity for lawyers to actually do criminal work, which involves 1, maximum 2, 3 hearings in a bail matter, is far more. So the disinclination towards the civil side of the profession, that is for all to see. And neither are they interested in doing civil work, nor do they want to take up civil work, because civil is very technical. Civil involves a lot of reading. Criminal is also, there is an art in doing criminal, but criminal, at least bails and all, it doesn't involve the same kind of hard work, the same kind of preparation as a civil revision or a regular second appeal, etc., would involve. So that is, I think, what is the biggest problem, right, with youngsters. And the profession is not going to grow. The profession is not going to grow if we do that. Because, see, I mean, criminal law, so far as the bail jurisprudence is concerned, is very judge-centric also.
Hmm.
Unlike and law, yes, there are judgments on bail, etc., but ultimately you have to apply that in the facts of a case, and then it is a lot of discretion based so far as granting bails is concerned. Civil, on the other hand, if you are prepared, if you make out a point, and if you have law to support you, then you kind of bind the judge. So civil is like that, criminal is very judge-centric, I believe.
Okay. And so I think finally something that I must ask you is, what is your opinion on the current tussle happening between, the central government and the Supreme Court on judges' appointments?
Oh, yes, yes. That's been a burning issue since the year 1993, I believe. I know, I personally believe that if you have to maintain the independence of the judiciary, the argument is open from both sides. If you take the example of the United States, that's one. You take the example of our country. I believe our country is the only country where judges choose judges.
Right.
But whatever happened way back in the 1975 time when we were in emergency, all of us have read it. What happened? What used to happen in the 1990s, which triggered the first judges case. I don't know. I think the jury is out. I think the current system of appointing judges is a good system. Yes, no system is perfect, but given an option, and this is completely my personal view, given an option, I believe the collegium system, compared to the involvement of the government in appointing judges, I think I would choose the collegium system any day. Yes, it is not perfect. You can make changes. In fact, in the NJAC judgment, when they came out with the memorandum of procedure, the MOP is what we call it, that also needs to be implemented in letter and spirit. Whether you like it, you don't like it, you have to follow it. But I don't think that the way the government is delaying the appointment of judges, that also doesn't give a very good impression, because these are ultimately constitutional functionaries. We can't lead to come to a situation where it seems as if everything's broken down. So I think the creative system is okay. Yeah, not perfect, but it's okay.
Yeah, and there's a lot being said in the public forum, in the public space, by the central government. What do you think about that? What do you think about the approach that's been taken?
Well, we live in a democracy. Everybody has the freedom and the right to air their opinions. But at the same time, when it comes from the senior functionaries in the government, there should be some element of moderation, and it's essential, because what you voice in public is treated as the voice of the government. And the last thing we want in a democracy, yes, there'll be a tussle between the executive and the judicial. That has been happening for the longest time, and it will continue to happen. But when you voice it in the open, in public, then it creates that impression in the public estimation that the government and the judiciary are not on the same page, because the end result should be to have an independent judiciary. We have to strengthen the judiciary and not cast a doubt over the people who are ultimately determining the decisions of the executive or the legislature. So for the purpose of the independence of the judiciary, I believe those should be moderated, and there should be some level of restraint that should be exercised by all. Like judges I've not seen judges, current judges at least, go out on a public platform and defend why the collegium system is better, etc. They don't do it. And I admire the kind of restraint that judges show. And I believe that the government functionaries should also follow suit.
And so, as a parting note, any advice, any tips for young lawyers, anything that you want to share from your years of experience?
Yes, absolutely. I mean, there are no shortcuts in this profession. The one thing that you have is your hard work, your diligence, and your integrity. These three things, they are non-negotiable. Everything else would be luck, destiny. I'm not going into percentage, but whatever I have and whatever I would advise, that prepare well, be polite in court, be firm in court when you have to be, don't be rude, and do not adopt any shortcuts. It's a noble profession. It's a wonderful profession. It is a profession in which God has given you the opportunity to represent somebody who's ultimately lost all hope, and his only hope is now the judiciary. Just imagine the plight of that person who's come to you, and treat a case as if it's your personal case till the time you argue it. And after that, you need to learn to be detached. But while you're pursuing that case, you need to be attached to that case, because that is the only way that you'll be able to deliver the goods. Do justice to yourself, do justice to the profession that you're a part of, do justice to the client who has reposed faith in you. And yeah, may he get justice. And you are basically a very important, you play a very important role in the dispensation of justice. And that, and one advice to a youngster and what I've been seeing, so the judges have a very, very tough job, very tough. And the best way that we can actually ensure that they do what they are there for is by being very well prepared with our cases to render absolutely wonderful assistance to the court. And then the court may decide one way or the other. That's the court's prerogative based on law or any other things. So yeah, that's my advice to youngsters, and I wish them well in this profession.
That is very valuable, and thank you so much for speaking to us and taking the time today.
Thank you so much, Shagun. It was such a pleasure talking to you.
Thank you.
Subscribe to our YouTube channel and click the bell icon.